Let's take a look at mandatory benefits. Employers are required to make contributions on behalf of employees into several social insurance programs. These include Social Security, unemployment insurance, and workers' compensation for replacement of income and medical expenses arising from workplace injury. Leave provided under the FMLA can also be thought of as a type of legally mandated benefit, although it does not require that paid time off be provided beyond the employer's own leave policy. Employers are not, strictly speaking, required to offer group health plans, although larger employers may be subject to monetary penalties if they fail to do so. The general rule is that employers are not legally required to provide health insurance, pensions, disability insurance, life insurance, or any other benefit. These laws come into play only after an employer has decided to offer benefit plans and determined how generous those plans will be. Despite its name, the Employee Retirement Income Security Act, ERISA, governs benefit plans broadly and is not concerned only with pension. ERISA covers most employer and labor union-sponsored benefit plans, but not government employer plans. The social insurance programs like Social Security are not covered by ERISA. Under ERISA, benefit plans are classified as either pension or welfare plans. Pension plans are designed to provide retirement income to employees or to otherwise defer income until after retirement, like defined benefit plans, 401ks, employee stock ownership plans, and profit sharing. Welfare plans are essentially any other benefit plans covered by ERISA that are not pension plans, like health insurance, child care subsidies, and paid legal services. Some exclusions exist, like premium pay for shift, overtime, and holiday pay, payment for non-work time that comes out of general assets like sick paid or paid vacations, and scholarship or tuition reimbursement and occasional gifts. States often address issues not covered by federal laws or provide a greater protection for employees. In general, states are free to fill in where federal law is silent or to mandate greater protection of employees. However, such is not the case when it comes to benefit plans covered by ERISA. ERISA is unusual among employment laws in its sweeping preemption language. Specifically, ERISA supersedes state laws, even remotely relating to the regulation of benefit plans. This technical legal issue has real consequence. Disputes that relate to benefits and depend on interpretation of benefit plans for their resolution must be framed under ERISA. Also, because the remedies and requirements of ERISA, particularly those that apply to welfare plans, are quite limited, achieving uniformity across states in the legal rules for benefit plans sometimes causes less employee protection. ERISA is a complex law that contains four main parts or titles. It combines provisions relating to employee rights with rules relating to the treatment of benefit plans under the tax code. Qualified plans receive favorable tax treatment, which provides employers with a strong incentive to conform to ERISA's requirement. Under ERISA, employers are required to inform employees about their benefits, provide claims and appeals procedures, manage plans wisely in employees' interests, and refrain from interfering with beneficiaries. ERISA's requirements focus on employee rights provisions of Title I. Eligibility criteria and the terms and conditions of benefit plans are often complex. A basic premise of ERISA is that informing employees about their benefits helps ensure that employees actually receive the benefits to which they're entitled. Benefit plan administrators are required to periodically, and at no charge, provide employees with reports and respond to employee requests for other information about their benefits. These reports include summary plan descriptions, summary of material modifications, and a summary of annual report. In addition, they include individual benefit statements and a disclosure notice. Summary plan descriptions are important documents. SPDs must be provided to employees within 90 days of their being covered under a benefit plan. Typically distributed in booklet form or online, SPDs must be written with a minimum of legalese and be sufficiently comprehensive and accurate to inform employees about their rights and obligations. In general terms, SPDs must identify the plan administrator, conditions for benefits eligibility, benefits offered, and procedures for claiming benefits and appealing denials. Full disclosure of the circumstances under which participants will become ineligible or lose benefits is particularly important. Apart from the reports provided to employees, ERISA requires that employers detail their benefits plans in written documents. Employers should be careful in advising employees regarding their benefits and refer them to summary plan descriptions and other plan documents. Employers are required to provide the benefits that they promise. Employees have the right under ERISA to sue their employers for denial of benefits. For example, a health plan might refuse to authorize treatment or decline to pay for care already received because it's deemed not medically necessary or experimental. If a denial of benefit case ends up in court, the nature of the review depends on whether the plan gives its administrator discretionary authority to determine eligibility for benefits and to interpret the terms of the plan. Because plan documents typically provide plan administrators with this authority, courts must often consider whether plan administrators abuse their discretion by making decisions in an arbitrary or capricious manner. This is known as the abuse of discretion standard. The relevant question under this standard is whether the plan administrator's decision was unreasonable, not whether it was incorrect. Questions about the appropriate standard for review also arise because there's sometimes a conflict of interest, such as the entity administering the benefit plan has a direct financial stake in limiting access to benefits. The Supreme Court has said that courts are entitled to weigh conflicts of interest as a factor in considering whether plan administrators have violated ERISA by denying promised benefits, but that would abuse the discretion remains the standard. The court has also held that even when a plan administrator is found to have abused its discretion in initial benefits determination, subsequent interpretations are still entitled to deference. The abuse of discretion standard commonly used in ERISA denial of benefits cases is a deferential to plan administrators, but it does not give them the license to unreasonably withhold benefits. Administration must base benefit determinations on plan documents, have reasons for their decisions, and use all current information available to them. Employers are required to provide reasonable claims and appeals procedures for their benefit plans. This means meeting certain minimum procedural standards. The standards for handling claims for health benefits are more stringent than those that apply to claims for other types of benefits. To be reasonable, claims procedures cannot inhibit the filing or processing of claims, such as by imposing filing fees. Decisions on initial claims generally must be made within 90 days. However, benefits determinations under health plans must be made more quickly. Urgent care claims must be decided within 72 hours, whereas claims for treatment already received must be decided within 30 days. The time limits on benefit determinations can be extended under certain circumstances. If a decision is made to deny a benefit claim, the specific reasons for the denial must be provided to the employee in writing. There must be a procedure for appealing adverse benefit determinations, and the procedure must allow 60 days for appeals to be filed. The results of these reviews must be communicated to employees within 60 days. Unlike under most employment laws, employees are generally required under ERISA to use their employer's claims and appeals procedures before going to court to sue for denial of benefits. Thus, an employee was unable to sue his health plan for refusing to pay for a prescription drug that he needed because he made only a single telephone inquiry about whether the drug was covered and he never used the appeals process. Conversely, an employee did not fail to exhaust the internal appeals process when she sent a number of letters seeking severance pay, but the letters were addressed to the wrong individual in the company's human resource department. The letters could have easily been forwarded to the correct individual, and the employee was never given the correct information about the claims and appeals procedure. In general, anyone who exercises discretionary authority or control over the administration of a benefit plan or its funds is considered a fiduciary. This role usually includes people such as directors, officers, plan administrators, and trustees. Outside parties that regularly render investment advice for a fee also are fiduciaries. The people or entities that control and manage benefit plans have a number of important responsibilities or fiduciary duty. First and foremost, fiduciaries are responsible for managing benefit plans and funds solely in the interest of plan beneficiaries and for the purpose of providing them with benefits. Fiduciaries must manage benefit plans with skill, care, and prudence. They must ensure that plans operate in accordance with plan documents and the requirements of ERISA. With pension funds, fiduciaries are responsible for diversifying plan assets to minimize the risk of large losses, selecting proper investments, monitoring investment performance, and ensuring that plans can meet their obligations. Fiduciaries must also refrain from engaging in certain transactions that have the potential to create conflicts of interest. The fiduciary duties of employers extend to information provided to employees regarding their benefits. An employer violated ERISA when it knowingly misled employees, inducing them to make a disadvantageous switch in benefit plans. The employer told employees that their benefits would remain secure if they voluntarily transferred to the benefit plans of a new subsidiary, even though the employer knew full well that the subsidiary was already insolvent. The Supreme Court concluded that there was a clear breach of fiduciary duty. In contrast, there was no breach of fiduciary duty when a mid-level benefits administrator manager misinformed an employee about the pension consequences of participating in the employer's workforce reduction program. Even though the former employee ended up with a much smaller pension than anticipated, the manager was not acting in a fiduciary capacity when he researched and informed the man about the expected value of his pension. Employers and ERISA fiduciaries must provide accurate information about benefit plans and not withhold material facts that would likely affect the interest of plan beneficiaries. ERISA prohibits discrimination against a benefit plan participant or beneficiary for exercising any rights to which he is entitled under a benefit plan. The employer must not, for example, fire an employee to prevent him from becoming entitled to receive a pension. Moreover, this protection applies to both pension and welfare plans. Although the statutory language appears relatively broad, courts have restricted this protection to cases in which adverse employment decisions was made for the express purpose of interfering with benefit entitlement. The mere fact that a loss of benefits accompanies a termination does not render a termination violation under ERISA. Courts have also generally limited claims to cases involving discharges or discipline. Refusal to hire or rehire an employee, even if motivated by a desire to avoid benefit costs, is not prohibited by this section of ERISA. However, an ERISA interference claim brought by a plaintiff who alleged that their employer cut their hours and pay based on its desire to avoid anticipated cost increases under Obamacare was upheld. The court focused on the employer's specific intent to reduce the number of employees receiving health insurance, a motive repeatedly expressed by management in meetings with employees. Employers must not discharge or discriminate against employees because they use benefits to which they're entitled to or prevent them from using benefits in which they're entitled. Individuals depend on income that is deferred into pension plans to provide for their retirement. If problems with a pension plan are not discovered until retirement is at hand, it's far too late to do anything about it. ERISA was created in large part to prevent such disasters, and it contains many requirements specific to pension plans. However, some types of pensions are more closely regulated than others. The less regulated variety is now the most common. In general, employers are free to alter or discontinue benefit plans at any time. The reduction or elimination of any benefit can be detrimental to employees, but pensions present a particular problem. ERISA allows pension plans to be modified or terminated, but it requires that plan participants and beneficiaries retain the benefits accrued prior to these changes. Under ERISA, employers with pension plans are required to provide for vesting of pension rights. Vesting means that after a specified number of years of service, employees covered under a pension plan acquired a non-forfeitable right to receive a pension. The period of time is usually either 5 years or 7 years. These vesting rules pertain only to an employer's contribution to a pension plan. Any employee contributions vest immediately. Once vested, an employee is entitled to a pension from the employer under certain circumstances to roll the funds into another retirement fund, even if the employee goes to work for another company. This does not mean that a 28-year-old who works 7 years for a company and then quits is entitled to a pension at that time. Rather, it means that on reaching the plan's minimum retirement age, the former employee is entitled to a pension. Because the size of a pension is closely related to length of service, the amount would probably be small in this case. Employers are required not only to vest the pension rights of employees, but also to offer benefits to survivors of deceased employees. The vesting of pension rights would not mean much of the employers remain free to diminish those rights by making changes to their pension plans that have the effect of reducing already earned benefits. Under ERISA's anti-cutback rule, employers are prohibited from making changes to pension plans that reduce pension benefits already accrued by employees. Thus, an employer that declined to pay a cost of living adjustment otherwise available under the pension plan to employees who opted to receive their benefits as a lump sum rather than an annuity violated ERISA. In addition to mandatory vesting, ERISA has participation requirements for pension plans aimed at broadening coverage. As a general rule, pension plans cannot exclude employees who are at least 21 years old and have at least 1 year of service. Limitations other than those based on age or years of service can still be imposed. Under ERISA, pension plans are categorized as either defined benefit or defined contribution plans. Legal requirements vary depending on the type of plan, with defined benefits plans being more closely regulated. As the name suggests, defined benefit plans promise a specific pension benefit on retirement. The size of an individual's pension is typically determined by a formula based on years of service and earnings. In establishing a defined benefit plan, an employer undertakes a long-term obligation to provide a specified level of retirement income to its employees. A pension fund is maintained separate from the employer's other assets, and benefits are paid from the fund. Obviously, adequate financing is the key to the operation of a defined benefit plan. In cases where an employer with a defined benefit pension plan is unable to meet its obligations to retirees, the Pension Benefit Guaranty Corporation intervenes. Employers with a defined benefit plan pay termination insurance, and these funds are used to pay the PBGC to provide at least partial retirement benefits to retirees and vested employees. The many types of defined contribution plans include 401ks, profit-sharing plans, stock bonus plans, and employee stock ownership plans known as ESOPs. In all of these plans, contributions are made into individual employee accounts. The funds in these accounts are portable, so they can be moved to other retirement plans when employees change jobs. The pension benefit that employees receive is not specified beforehand and depends instead on the amounts of these individual has in a retirement account at the time of retirement. In turn, those amounts are linked to choices about how much income to defer, whether employee contributions are matched by their employers, which investments are selected, and what gains or losses are from those investments. Thus, with defined contribution plans, employers establish plans and define what their own contributions, if any, will be. They make no commitments regarding eventual payout to employees. Policymakers have become to respond to the reality of a pension system in which defined contribution plans are the norm. The Sarbanes-Oxley Act requires that employees receive 30-day notice of blackout periods that would affect their ability to direct investments or receive contributions from their 401k. The law provides that corporate insiders will also be subject to any blackout periods, meaning that they will be unable to sell shares or exercise stock options when employees with 401ks are so restricted. While defined contribution plans are not governed by the extensive funding and administrative requirements, employers and other decision makers still have a basic fiduciary duty towards participants in defined contribution plans. Employers should do a few basic things regarding 401ks and other defined contribution plans. First, employers must invest the funds deducted from employees' pay no later than 15 business days after the end of the month in which deductions are made. Second, employers should carefully research investments, offer a wide range of types and companies from choose from, and warn employees regarding the dangers of inadequate diversification. Third, employers should provide regular opportunities for employees to divest themselves of company stock and place those funds in other investments. Fourth, employers should make impartial investment information available to employees. Fifth, employers should consider placing responsible or reasonable limits on the extent to which employee accounts compromise company stock and should remove company stock as an investment option when it's no longer a prudent investment. Finally, employers must not violate their fiduciary duty to manage plans in the best interest of employees while imposing lockdowns for illegitimate purposes. In 2010, the Patient Protection and Affordable Care Act, known as the PPACA, was signed into law. This law, also known as the Affordable Care Act, or ACA, or Obamacare, is intended to ensure that most Americans will have health insurance coverage and receive quality medical care. At this time, the law includes a number of measures aimed at lowering the costs of health care. The ACA is a complex statute. In large part, the law's complexity stems from its ambitious objectives and need for a comprehensive approach to achieve those objectives. A political judgment was made to build on existing sources of health insurance coverage rather than create a simpler, single-payer system modeled after the Medicare program that serves as the primary health insurance for most older persons. The ACA's basic strategy for expanding health insurance coverage is to increase enrollment in Medicaid by making more people eligible and maintain the same level of coverage under employer-sponsored group health plans. It also seeks to stimulate a viable market for individual health insurance plans by making subsidies available for the purchase of such plans and creating online exchanges to facilitate purchase. Prior to the implementation of the ACA in 2013, the U.S. population was covered in a variety of ways. 50% under employer-sponsored plans, a little less than 30% under government plans, approximately 5% under individual health plans, and the remainder of the population was uninsured. For the most part, individual plans provided limited coverage and were not available to people with pre-existing conditions as well as serious health problems. The ACA sought numerous health insurers to compete in the market, forming large pools of insured persons with different health statuses to offset the costs of covering persons with extensive healthcare needs. Health insurance reform has been controversial. A stream of lawsuits have been filed challenging different aspects of the ACA. In one of these cases, the plaintiffs alleged that the federal government exceeded its authority under the Constitution by requiring that individuals purchase health insurance or pay a penalty. The Supreme Court majority agreed that the government did not have the authority under the Commerce Clause to compel individuals to purchase an unwanted product. They also agreed that states could not be threatened with loss of all Medicaid funds if they chose not to expand their program. However, the ACA was upheld as constitutional on the grounds that it amounted to a tax on the lack of health insurance. The individual mandate fell within Congress's taxation powers. Congress subsequently chose to eliminate this tax. There is a case to be made that the ACA has improved the health insurance situation in the United States, despite the many implementation problems and strong headwinds of resistance that it's faced. However, the legal and political issues surrounding this law are not likely to subside anytime soon. Congress might persist and ultimately succeed in its quest to amend or repeal the ACA. Actions by the executive branch of the U.S. government might further contribute to the climate of uncertainty surrounding the law and dissuade insurers from participating in the individual plan market. While many aspects of the ACA are quite popular and could be here to stay, it's doubtful that a piecemeal approach to health insurance will work. Whatever happens, the ACA's ambitious objectives of ensuring the uninsured, providing access to quality medical care, and controlling healthcare costs remain as relevant as ever. In 1985, an effort to deal with the problem of uninsured focused on circumstances that caused individuals to lose their coverage and provided them with a means of staying insured until they became covered under other group health plans. The Consolidated Omnibus Budget Reconciliation Act, or COBRA, applies to employers that have group health insurance plans and at least 20 employees. They must offer continuation coverage to employees and their beneficiaries who experience qualifying events that would otherwise cause the loss of their health insurance. Qualifying events and the periods of time for which coverage must be maintained are as follows: continue coverage for up to 18 months, voluntary or involuntary termination of employment for reasons other than gross misconduct, and reduced hours of employment. Continuing coverage for up to 36 months for divorce or legal separation, death of an employee, a loss of dependent child status under the terms of the health plan, or a covered employee becomes eligible for Medicare. One of these qualifying events occurs, an employer must offer continuation coverage to the employee and other family members who have been covered under the employee health insurance program. Employers cannot simply be dropped from health plans without following COBRA's procedures. The continuation coverage must be the same coverage enjoyed by employees who have not experienced a qualifying event. Information about COBRA rights must be provided to covered employees and their spouses and be included in the health plan SPD at the time the health plan coverage begins. Employers must notify plan administrators of the occurrence of qualifying events within 30 days. Because employers would not necessarily know if divorces, separations, or loss of dependent child status occurs, employees and other beneficiaries are responsible for bringing these events to the attention of plan administrators within 60 days. After they're alerted that a qualifying event has occurred, plan administrators have 14 days to offer continuation coverage. Notice should go to all adult beneficiaries, not just to covered employees. Beneficiaries must be given at least 60 days from the time their health coverage ends or from when they're notified of their COBRA rights, whichever is later, to elect continuation coverage, and 45 days to make their first payment. Beneficiaries can be charged up to 102% of the cost to the employer for providing coverage under the group health plan. This is a major expense for most employees and their family members. With the opening up of the individual health plan market under the ACA and the availability of subsidies in some cases for the purchase of plans through exchanges, COBRA coverage will probably become less common. If an employee elects continuation coverage, the coverage must continue for the applicable time frame unless the employer discontinues offering group health insurance to its employees. Coverage would also be discontinued if the employee fails to make the payments or becomes covered under another group health plan. Medicare is designed to be the primary health insurance for retired persons, but it provides only partial coverage of medical costs and is not available to younger retirees. In the face of rapidly rising health costs, many employers have cut back or completely eliminated health insurance coverage for their retirees. This has raised the question of whether employers are ever legally bound to continue providing health insurance coverage to retirees. These cases, which often involve retiree health benefits contained in collective bargaining agreements, consider whether employers intended to confer an irrevocable right to receive health benefits on retirees for their lifetimes. The Supreme Court has held that there is no special presumption that collectively bargained retiree health benefits are not revocable. Instead, courts must apply ordinary contract principles to ascertain the intent of the parties when they negotiated for retiree health benefits. Retirees are likely to have difficulty convincing courts that their former employers should be bound to providing this or other welfare benefits that, unlike pensions, do not vest. Some benefits, including life insurance, disability insurance, and health insurance, are more expensive to provide for older workers. The Older Workers Benefit Protection Act, which amended the Age Discrimination in Employment Act, takes account of this fact. Employers are permitted to provide less extensive coverage for older workers so long as the amount spent to provide benefits to older workers is at least equal to the amount spent providing these benefits to other workers. The cost equalization principle applies only to welfare plans whose cost is age-related and not to pension plans. Certain offsets or deductions from benefits received by older workers in exchange for other benefits are permitted. Employers that provide retiree health insurance can lawfully reduce or eliminate health benefits for retirees when they turn 65 and become eligible for Medicare coverage. Regarding pensions, plans can establish minimum ages for receipt of pension benefits and normal retirement ages. However, older workers must be allowed to participate in and continue accruing benefits under pension plans regardless of how old they are when they were first employed or whether their age now exceeds the normal retirement age under the plan. An employer violated the ADEA when it required its older employees to pay a larger percentage of their pay into retirement plans that were required of younger employees, even when the two were hired at the same time. Since employees were able to retire based on reaching a specified number of years of service, older employees were being charged more for the same retirement benefit than younger employees with the same length of service. Disabled persons have a particularly great need for health insurance. At the same time, this might provide some employers owing and concerns about the rising cost of health insurance with an incentive to discriminate against these individuals. Clearly, employers cannot refuse to hire or terminate disabled persons based on the assumption or even the fact that they are, on average, more expensive to insure. Basing employment decisions on disability is disparate treatment and violates the Americans with Disabilities Act. Employers are also prohibited from discriminating against an employee because that employee is associated with a disabled family member who might be a heavy user of health benefits. An employer also violates the ADA by refusing to provide health coverage to employees with disabilities if health coverage is provided to non-disabled employees. Thus, the ADA was violated when an employer charged group health plans to a new insurer refused to cover an employee who previously had cancer and currently had AIDS. Group health plans and the issues of health insurance coverage under group plans also must comply with the Genetic Information Non-Discrimination Act. This law requires that premiums and contribution amounts for groups must not be adjusted on the basis of genetic information. Additionally, group health plans and insurers cannot request employees or their family members to undergo genetic testing and are prohibited from collecting in any way genetic information about employees prior to enrollment in coverage. The Health Insurance Portability and Accountability, or HIPAA Act, predicated the ACA by more than 2 decades and was an important but limited attempt at health insurance reform. HIPAA focused primarily on employer-sponsored group health plans. Two of HIPAA's most important provisions were its non-discrimination requirements and the limitations it placed on the use of pre-existing condition exclusions. Under HIPAA, group health plans are prohibited from denying eligibility for benefits or charging more for coverage based on any health factor. Health factor is defined broadly to include the health status, medical condition, claims experience, receipt of health care, medical history, genetic information, evidence of insurability, or disability of an employee or dependent. HIPAA also restricted the use of pre-existing condition exclusions, periods of time for which a health plan would not cover the treatment of conditions predating enrollment in the plan, but did not eliminate them altogether. The ACA incorporates and expands upon many of HIPAA's protections. Pre-existing condition exclusions are now prohibited for both individual and group health plans. Many employers, especially larger ones, have turned to wellness programs as means of lowering health insurance costs by improving employee health. Wellness programs vary widely in comprehensiveness, beginning with programs that merely dispense information or offer opportunities for physical activity or provide health screenings. Others provide incentives or penalties based on achievement of specified health outcomes or focus on actively managing expensive and potentially debilitating chronic diseases. Participation in wellness programs tends to be low in the absence of incentives or penalties, lower or higher health insurance premiums. So, those are common program features. Wellness programs frequently include periodic surveys of employees, known as health risk assessments, and screenings for the likes of high blood pressure, cholesterol, and blood sugar. Despite their potential to be mutually beneficial to employees and employers, wellness programs are controversial. Several federal laws converge around wellness programs. Wellness programs that base rewards or penalties on standards related to health factors, they can violate the HIPAA or ACA non-discrimination requirements if employees are charged more for their health insurance coverage. Under these laws, it's important that plans be reasonably designed, which includes offering annual opportunities for incentives, providing reasonable alternative standards, not requiring participation as a condition of coverage, and limiting the size of incentives or penalties. Wellness programs also raise questions under the ADA and GINA. Disabled employees are more likely to have difficulty meeting health-related standards required to earn incentives or avoid penalty. More generally, the health-related information gathered through health risk assessments or screening is not job-related and consistent with business necessity. The EEOC has issued guidelines for wellness programs that correspond to HIPAA and the ACA requirements, but do not limit to outcome-based programs that tie incentives or penalties to meeting health standards. The EEOC's requirements include not imposing a burdensome time commitment or cost, refraining from overly intrusive inquiries, and not denying coverage for employees who choose not to participate. Further, notifying employees about which information will be collected, used, and stored, and not imposing penalties exceeding 30% of cost. Because health risk assessments inquire into family history, the GINA Wellness Program rules are mostly the same as for the ADA, although GINA requires employees' signed authorization rather than simply notice to employees. The EEOC's new guidelines on wellness programs have already been challenged, and a court has ordered the agency to reconsider its guidelines. Congress is debating legislation, and courts are deciding cases on varying grounds. Finally, the Pregnancy Discrimination Act has implications for health plans. The basic principle of the PDA is that pregnant employees are entitled to the same treatment as non-pregnant employees with similar ability to work. Health plans must cover expenses for pregnancy-related medical care on the same basis as expenses for other medical conditions. An exception is that health plans can refuse to pay for the cost of abortions where the life of the mother is not endangered. Not only must pregnancy-related medical costs be covered, but health plans are prohibited from imposing higher deductibles or copayments for pregnancy-related treatment. Additionally, coverage of pregnancy-related treatment cannot be limited to married couples.